Hi, Stefano Molea here, San Diego criminal defense lawyer and partner at the law office of P. Shapiro, where we help good people regain control of their future when charged with a crime. And in this video, I want to briefly talk about a severance motion. A severance motion is one that's typically made by the defense when the defense lawyer wants to sever or separate certain counts in a complaint or sever co-defendants in a complaint. This is typically done before a trial, right? And so essentially what the defense lawyer is saying is, hey, I want different juries for these counts versus these other counts, or I want separate juries to address the charges against one defendant and the other. Now, the severance for a co-defendant case, as far as just severing the defendants themselves, is usually more common. And so I'm going to just talk about a brief example to provide some context there. But the factors that go into deciding whether to sever a case or sever counts are somewhat similar. So let's talk about a scenario, for example, where someone is charged with murder and another person is charged with accessory after the fact, meaning that after the murder was committed, the other person helped the alleged killer avoid arrest or detention, helped him escape or try to hide evidence, that sort of thing, okay? The two cases are at the opposite end of the spectrum as far as severity and potential exposure to custody. The homicide, the murder, carries potentially life in prison. The accessory after the fact carries a maximum of 3 years. Okay, so in this situation, as a defense lawyer, I would very likely want to file a severance motion to have my client, let's say that my client is charged with accessory after the fact, be tried separately than the person charged with murder. And here's some of the factors that the judge, in hearing this motion by defense counsel, is supposed to consider. One, if they were tried together, would the co-defendant's case and the evidence related to that co-defendant, let's say the person charged with murder, inflame the passions of the jury against my client just by association? You can imagine in a case like the one I just described, there's a decent likelihood of that happening. The other factor, one of the other factors, is whether or not there's some evidence that's relevant for the homicide case, but not necessarily relevant for the accessory after the fact case. And so how do we deal with a situation where the same jury is supposed to hear evidence related to the murder, but the defense lawyer for the person charged with accessory after the fact is going to say, hey judge, that evidence is not relevant to my guy or my client. So how do we get the jury to only consider the evidence for one person and not the other? There may be an attempt with an admonition or an instruction by the judge, hey jury, only consider this evidence as the defendant 1 but not defendant 2. As you can imagine, that's not realistic as far as it being effective. And as they say, you can't unring the bell, okay? So that's one issue. And then, the other sort of important issue is if a strong case against one defendant is essentially used to bolster a weak case against the other. So let's say the case against the homicide defendant is very strong, and they're now essentially using that power, right, the power that comes with a strong case to loop in or kind of sweep in the weaker case and just convince the jury potentially to just convict them all because they're all part of the same package. That's problematic. And so that would be another basis typically to argue for a severance. So those are just some of the factors, but those are, in my estimation, are some of the more important ones. And it just really highlights the significance of this type of motion in preserving the right to a fair trial. So hopefully this information was helpful. If you have any questions, feel free to leave them in the comments or give us a call. Our phone number is 619-295-3733. 3555. Again, my name is Stefano Molea. I'm a partner here at the law office of David P. Shapiro.